Hello, my name is Christina Gornail. I'm one of your labor attorneys from the law firm of Phillips, Richard & Rind. You may know Mark Richard and Kathleen Phillips, partners with over 65 years of combined experience working for unions like the TWU. I have been at the table with your negotiating committee since March, working with our financial and bankruptcy experts during this difficult and painful process. From this perspective, I would like to discuss some information that may assist you in casting your vote. We know that this process is not easy. The company's original ask we saw in March and the 1113 term sheet filed with the court in September are asking for things that will change your paycheck and your quality of life. All options will make you worse off than you are today, because unfortunately, bankruptcy is a concessionary process. We could not change that. What we could change was how we reached our target. Our goal was to minimize the impact on your weekly paycheck as much as possible, while protecting as much of the contract as we could. Throughout negotiations, we had to consider the fact that you work for American Eagle, not American Airlines. Because of this, your contracts, while related, are different from those at American. This means that we had less areas of your contract to take from in reaching our $7 million ask. What we sent out for a vote in July was the best option we had at the time for a 6-year contract. That tentative agreement was not perfect, but it did preserve many of the benefits in your current contract. That being said, we listened to your vote and to your concerns during informational sessions, in emails to your executive boards, in lunchrooms, and in the hangars. We heard your issues regarding time off and pay, and we came back to the table to attempt to fix those issues this time around. What you are voting on now preserves much of the savings we made after the 4 months of original negotiations, with some changes that hopefully make this bitter pill a little easier to swallow. The first thing you will notice is that this proposed contract is 8 years. Although we tried, there was not enough room to move on the last 6-year TA without either drastically cutting your pay or cutting time off. Through an 8-year agreement, we were able to come back to you offering no pay cuts, no pay freezes, and no changes to any of your premiums. Although double time and daily overtime are eliminated, you will still have the opportunity for weekly overtime, which is in line with federal law. If this agreement is ratified, you will still receive the 1.5% increases in 2015 and 2016, and you will still be eligible for the enhanced profit sharing plan. This time, the reduction to the company's 401k match is now just 1% across the board instead of 2%. In addition, topped-out AMTs will now be entitled to a $23,300 early out. These options would not have been available with a 6-year agreement. Also, in 4 years, there will be an opportunity to renegotiate during an amendment round. Details are available online and from your local presidents, but basically the amendment round is more like a shorter version of regular Section 6 negotiations, with an opportunity to bring 5 contractual issues to an arbitrator if we cannot reach an agreement during that time. Regarding time off, you will see that this proposed agreement includes a new system for vacation and sick days, called Personal Days Off, or PDOs. Unlike the company's original ask from March and the term sheet they filed in court, the version you are voting on preserves current vacation time plus 3 additional days. If you review the full text language and side-by-side comparison, you will see that although there are some changes, we preserved much of current Articles 5 and 7 regarding vacation and sick time. You will still bid on vacation time, now called consecutive personal days off, for all but 8 days. You can use the other 8 days throughout the year at your discretion, except in certain limited circumstances. At the end of the year, you will have the option to either bank the hours in a catastrophic sick bank, or you can cash out up to 40 hours. This means that if you're a 12-year employee, you will still accrue the same 3 weeks of vacation you have today, now referred to as PDO, plus 3 days. You will bid on 2 weeks using the same bidding process used currently, and then you will have 8 personal days to use throughout the year. If you would prefer to save up a week and get an extra week of pay at the end of the year, you can do that, or you can bank it all to use in the future. It's your choice. The company's original PDO proposal was much worse, with less time and more restrictions. If you vote to reject this proposed agreement, unfortunately the benefits that we were able to preserve in the TA are at risk. If Judge Lane does reject your contract, you will have no collective bargaining agreement, no scope, no outsourcing protection, pay cuts for all title groups, loss of double time and daily overtime, no crew chiefs, hits to shift premiums, a worse PDO system, and all of the other terms that the company asked for in its 1113 term sheet filed with the court. Although we cannot guarantee how the judge will rule in just a few weeks, based on what we have seen in past bankruptcy cases, the risk that he will rule in the company's favor and reject your contract is high. Please review the company's August 1113 term sheet filed with the court to see what terms Eagle has said you will work under if the contract is terminated. Then, review the side-by-side comparisons and the full text to see the proposed contract you are voting on. Go to informational meetings, ask questions, and vote. Thank you.